The next matter to come before the court is Donald Parker versus Wilson.
Thank you.
Good morning, gentlemen.
Good morning, Your Honor.
As you know, each side will have 15 minutes to present oral argument. Mr. Flowers, as you represent the appellant, you go first. You may reserve up to 5 minutes for rebuttal. You'll let me know, I will be keeping.
3 minutes will be fine, Your Honor.
Okay.
May it please the court, my name is Paul Flowers. I represent the plaintiff appellant, Donald Kevin Parker, in this appeal. We have a very straightforward appeal in a premises liability case this morning. Summary judgment was granted below, so the standard review here is de novo. The only issue raised by the defendants below in their summary judgment motion was the open and obvious defense, and the actual facts of the incident are not in dispute. What had happened was that my client was traveling through Akron. He was flying out of Akron Canton Airport the next morning, and he booked a room at the Red Roof Inn in the, I want to say LA, Lower Akron, with the South Arlington Road. He backs his truck into the parking lot and goes into his room, comes back out. It's his first time there, never been to this Red Roof Inn before. He's tending to the back of his truck, securing everything, making sure it's all in there, kind of moving around the back. When he feels his feet go out from under him, falls down an embankment and severely injures his wrist. The lawsuit is brought, and as I indicated, summary judgment was granted on that defense. And our contention is that the trial judge erred by rendering essentially a factual determination, finding that Mr. Parker's own inattentiveness outweighed any responsibility of the hotel, and therefore justified summary judgment. And that's contrary to the consensus of authority. We're not disputing in this case that this was the type of hazard that upon inspection would be visible. It's not a latent defect in any sense. The question here is whether there were attendant circumstances that justified a jury trial in this case. And attendant circumstances have been defined as a distraction or a diversion that prevents the plaintiff from seeing the hazard or appreciating the hazard.
Aren't the attendant circumstances in this case him messing around in the back of the truck? He didn't back down, he didn't back over into the...
Correct.
So he already knew it was there, he didn't back into it in the first place when he parked there.
I don't know if it's fair to say that he knew it was there, because if you look at the photographs, there are posts, so that they don't have the railing system that's required by law. They have posts set up in their space so the vehicles can't go over, so he backed up to the post.
Did he hit the post?
Not that we know of, but he would have backed up to the post. There's no evidence of record that he would have seen what was on the other side of the post, because that would require getting out and then looking down. But here, it's, all we have in the record is his deposition testimony that does have to be accepted. It's true in the summary judgment stage. And it's, that he has to secure his truck, make sure everything's in there and taper down before he goes into his room and goes to bed for the night. And that's, a responsibility he owes, and, it's hardly unusual.
But he backed in. He didn't pull and he backed in.
Correct, backed in. And, the hotel has to appreciate that people are going to be getting in and out of their vehicles, walking around their vehicles and so forth, and are not going to be focused strictly on, where their feet are going. There's going to be other circumstances. So just an example, you could easily think of more sympathetic facts, such as a mother with a disabled child who backs the van in, is in the process of getting the wheelchair out of the back and tumbles off over the unguarded edge. Are we going to say in that case that as a matter of law her inattentiveness bars the claim? I don't think so. The hotel should foresee that we have these regulations that require pedestrian guarding precisely because people are distracted.
So is your issue with the fact that the hotel constructed the parking lot at the very edge of this drop-off, or that the hotel did not create more of a barrier, or that there was something with the subsurface that created the ground to move, or all of the above?
Now, I would go with answer B, the second one. And it's one of the things that was surprising to me about this case, when you look at the photographs. Let me point out, I didn't mention this in my brief, but at the time that our summary judgment response was filed, an affidavit was filed from our expert, the trial court level, and the expert open and obvious is really not an expert issue, so we didn't cite it, but he does have photographs attached to it that I looked at this morning.
And we have those, and they'll be in the record.
Yeah, you can see on this, you can see the clerk's stamp at the bottom of the page here. But that's what's startling, is that, there's no pedestrian guarding here. You have a drop-off that goes straight down, and they have posts here, so they know there's a hazard, and they're protecting vehicles from going over, but they've done nothing to prevent a pedestrian from just stepping off the edge.
When you say posts, do you mean vertical posts?
Yeah, see these blue posts, they're wooden, and they're spaced, so that you can't get a vehicle over the edge.
Gotcha.
But a person easily, the post is going to be in the middle of the back of the car, you got the sides completely unprotected. And the expert does say, that there are a multitude of codes that require a guarding system, not just a curb bump, not like these tire stops that we have here, but an actual pedestrian guarding system here that they violated. And it's not a dispute, they didn't seek summary judgment on that issue, they've only sought summary judgment on open and obvious. So, yeah, I digress a bit, but I just wanted to point out that it's not, this was foreseeable. We have those regulations for a reason. It's because people wander around parking lots that are unfamiliar to them and step where they shouldn't. There were a number of cases I thought that really were contrary to the trial judge's decision here, one of which is the Yaki case. Out of this case, Yaki versus Best Buy. This court issued that decision just 2 years ago. And we had a plaintiff who tripped over a bunched up rug going into the Best Buy store. Summary judgment was granted, but this court reversed it and observed that, as this woman's walking into the Best Buy, there's signs all over, directing her attention. There's a deal here, there's a deal there. So it's foreseeable that she's not going to be looking at her feet as she walks in and is not going to see the bunched up rug. And therefore, although the hazard's visible upon inspection, there were attendant circumstances that justified a jury trial.
The attendant circumstances in that case, were created by the Best Buy store.
True.
The attendant circumstance in this case was created by the defendant looking around the back of his truck.
True, right. And that's not an impediment. I mean, I'm not aware of any case law that says that it has to be the defendant that creates the attendant circumstance. For example, the next case we're going to talk about is Lovejoy versus EMH, which is also out of this court. And you had a woman who's visiting a medical clinic, EMH Medical Center in Elyria. She's visiting the clinic. First time there, she says she's trying to find her way inside. She's also worried about traffic. And then she trips over a hazard. And this court said, well, she's obviously distracted. Now those are distractions that the hospital didn't create, that she doesn't know where she is and there's traffic. Can't really blame her for that either. It's attendant circumstances the jury has to sort through. So I would agree with you. Now, if the plaintiff creates their own hazard, that's one thing. But people have responsibilities to their vehicle, things they have to tend to. And this man's traveling on business. The products he has in the back of his truck are not his to leave open and exposed, while he goes to bed. So he's got some responsibilities there that require him to maneuver around his car. And
You could have pulled in.
If he pulled in front-wise, yes, he probably would be better off, but a lot of people like the back end. Maybe it makes the back of his truck look less accessible to somebody who's looking to commit a crime. But, like I said, inattentiveness is definitely an issue, but it's an issue the jury should sort through. It's just proximate cause, and that's not a valid summary judgment issue in a case like this. And that was the Kerr-Morris case we cited, which is out of the 1st District. And there you had a hotel guest who slipped and fell in the bathtub. And her argument was that the hotel should have replaced the no-slip strips on the bottom of the tub. And the hotel responded, you're the one who slipped, you weren't being attentive. And the first district agreed with her that, it is an issue. Maybe the jury will find that it was her fault and render a defense verdict, but there's no guarantees of that. So in the Kerr Morris case, they reversed and remanded for a jury trial. And that's all we're asking for here.
How did the court, I'm just trying to recall from reading the opinion, deal with the per se statutory issue?
I don't, if I remember right, she didn't mention it. And I don't blame her. I mean, it wasn't, this summary judgment issue has been very focused on open and obvious defense. And I don't,
That wasn't
I'm not criticizing the defense, but that is, the issue in this case. It certainly jumps out at me. And the court here, I believe, erred by, weighing the evidence, deciding that the plaintiff's own inattentiveness was the sole cause of the accident, and granting summary judgment. So we would ask this court to reverse. Thank you.
Please, the court. John Rasmussen on behalf of the defendants. Your Honor, if I could just address your last question about how the trial court, and I think when you're talking about the per se violation, you're talking about the building code issue?
Correct.
Okay. If I can paraphrase, make things go a little quicker. Parker contends a material issue of fact regarding the applicability of open and obvious because the parking lot was in violation of building codes. Even if the parking lot was in violation, the existence of such violations does not obviate the applicability of open and obvious. As long as the alleged violations were open and obvious, the doctrine applies and summary judgment for the property owner is still proper. Court cites Ryan versus Guan, 5th District case from 2004. So the court did address that. And as the appellee notes in his brief, attendance circumstances is the pivotal issue in this case. So that's what we're talking about. I don't think there's any real dispute that this embankment adjacent to the parking lot was open and obvious. The appellee's, or the appellant's focus in this case is whether attendance circumstances exist to obviate the application of open and obvious. Obviously, the trial court said no, that this was a hillside, that parking lots are frequently built adjacent to elevations. There's elevation changes within the parking lot itself, and that this is a very ordinary situation. As far as attendance circumstances, when we reviewed the conditions that existed at the time this accident occurred, it was the middle of the day in July. There were no adverse weather conditions whatsoever. As counsel noted, Mr. Parker backed his pickup truck into his parking space. There are some additional facts for consideration. Mr. Parker first got out of his truck and went to his room and had a short conversation with the housekeeper who was finishing up cleaning the room. He then turned and walked back to his truck, now facing the area where the obvious elevation change exists. So he had an opportunity, as he walked from his room across the parking lot to his truck, to see exactly what was out there. So we're not talking about, Mr. Parker as an individual. We're talking about, what a reasonably prudent business invitee to be aware of the fact that this hazard existed. So using that standard, which is the correct standard, the answer is yes, because you can just see that the ground disappears. Then you get into the actual conduct of Mr. Parker. He goes back into his truck to charge his phone, and then gets out and starts this process of checking the contents of his the truck, the bed of his pickup truck. And he walks from the driver's door alongside the pickup truck, and then as he gets to the rear corner where the bumper is, he has to take a bit of a wide turn because he's got a hitch in the middle of the rear. He's banged his shins on it a number of times before and knows that he has to take a few extra steps to get around it, and that's when he goes down the hill. The photographs that are in the record clearly show that his truck the bed of his truck was backed over a cement curb. Then there were parking bumpers, cement parking bumpers behind that. And then there was a section of loose stone behind that. And then behind the loose stone was the top of the cement wall that retained the retainer wall that kept the hillside back. So this was not a situation where he got out of his passenger door, took one step and went down the hill. That's not it at all. There was a lot of things that he had to step over a curb, he had to step over a parking bumper, he had to walk across the loose stone and then a top of the retaining wall before he even got to the point where he could fall down the hill.
What was the photo that Mr. Flowers made reference to, was that taken on the day of the fall?
I believe, if I understood correctly, that was taken by his expert sometime later, but it's an accurate depiction of the conditions that existed, and they're actually the exhibits that are in the record, and I believe they're attached to my brief, were identified by Mr. Parker in his deposition.
Was the truck in the photo?
Yes. The background to that is after he went to the hospital, he contacted a cousin in Indianapolis who came up and basically retrieved his truck and drove away. They took photographs of how the truck was positioned in the parking lot, and those are the
That
ones.
was my question.
Yes, those
Before
are the ones. Yes.
it was moved.
Right. So
Okay.
there
Because
are.
when you talked about how far it was back in and where the bumper was and so on and so forth, I'm trying to figure out how we know that, but that's helpful.
Yes, and Mr. Parker identified his truck and how it was parked and so forth. So it's one of those pictures does, say 1,000 words, because it's a little hard to envision, but it's very clear in the photos.
But to the point that you just made about, backing into a space and how close this is to the drop-off, isn't there an argument that a hotel would have to take into consideration in terms of design the fact that many people who travel do back into their spaces and would very often have to access their trunk in order to retrieve their suitcases and their belongings? And so is there a question of fact as to whether it was reasonable where there was a reasonable amount of space there, even taking into consideration those vertical poles, a reasonable amount of space for an individual who backed into that space to be able to access their trunk or the end of their truck?
Your question presumes the existence of a duty, Your Honor. And that's the whole point of the open and obvious doctrine, is that when you have an open and obvious hazardous condition, the property owner owes no duty because the hazard itself is the warning. So to take your analysis, it's that, by being a business invitee, it automatically creates this duty that you've spoken of to design appropriately and put up additional warnings. Counsel argues in his brief that there should have been warning signs and some other things back there to let invitees know. Well, the whole purpose of the open and obvious doctrine is that the hazard itself is there for all to see, and it's a clear, the hazard itself is the warning, then there is no duty on the part of the property owner to warn. So, we have a situation where there's no dispute that this is an open and obvious condition. And the sole issue before this court is, are there any attendant circumstances that excuse the application of the open and obvious doctrine? And I think that as we've pretty well beat to death at this point. Mr. Parker was clearly just looking in the back of his truck, and those facts in and of themselves don't create the attendant circumstances that are necessary to obviate the application of the doctrine. Okay. Thank you very much.
Thank you.
Just a few points in response. I think jurors could disagree that there were lots of things that Mr. Parker had to do to fall over that edge. I mean, the pictures tell it all, and it is unguarded. I mean, the only obstruction that is more than a few inches high are the posts. You know, they're only there to stop cars from going over the edge when they're being pulled in. That's it. A child could easily fall over the edge of that, because the only other barriers we have are maybe 3-4 inches, and those are the tire stops. There's no dispute they violated the regulations. There was a duty. We're just at the open and obvious defense and attendant circumstances, and that's all that really matters, because you just don't see this anymore where you have drop-offs in public parking lots that are unguarded. That's what's so surprising to me. You know, this argument that there's no duty for any hazard that's visible, that's not true, because that's the purpose of attendant circumstances. If that were the law, businesses could leave gaping holes in their floors, and anybody who fell in would only have themselves to blame, because there's no duty to guard against an obvious defect. And all the cases we cite in our brief indicate that that's just too simplistic. Often there's no duty, but when you have distracted customers, and you know you're going to have distracted customers, you have to guard against that. At the very least, it's a jury issue. I wanted to point out, I mean, the law remains the same that was announced in the Gross Nickel versus Village of Germantown case in 1965, but there's no duty on pedestrians to constantly look downward. These businesses have a responsibility to their invitees. They can't ignore those responsibilities by claiming the hazard's open and obvious. If this accident happened at night, there would be no open and obvious defense. The fact that it happens during the day doesn't make a difference when we're dealing with somebody who is plainly distracted by his own responsibilities to his vehicle and can't be watching out for himself. And particularly given that this is his first time, I believe, in Akron, and certainly his first time at this Red Roof Inn. It's not a situation like the cases they cite where you have somebody who's been there before, knows what the hazard is, and for whatever reason doesn't protect themselves. This is a set of facts that, based on the consensus of authority, should go to a jury trial. Thank you.
Thank you. Thank you both for your presentations. The court will take the matter under advisement. We will issue an opinion which will be sent to both parties, and you may certainly check on the Supreme Court website where you post it.
Thank you.